Ladies and gentlemen, boys and girls, welcome to another episode of Katiba na Chai. We read court judgment, so you don't have to. And then we have to explain why the government nearly invoiced someone for YouTube upload. This episode comes from a constitutional petition filed by one Mr. William Getumbe Kinyanjui. Weird name, but listen, I'm not experienced. Now, a social media content creator, and the question before the High Court was not a small question, it was this. Can the state use a 1962 film law to license what you record on your phone to upload on the internet today? Because if the answer was yes, then Kenya does not have content creators. No. It just has unlicensed cinematographers. Okay, let me tell you how we got here. So, Mr. Getumbe uploaded a music video on YouTube. And one of those videos attracted intense public backlash. The lyrics and imagery were widely described as vulgar, blasphemous, and degrading to women. And the phrase at the center of the controversy, Yesu Ninyandue, translated loosely to mean, Jesus, sleep with me, and I'm being polite here. Not metaphorical, not poetic, literal, a sexualized appeal directed at a religious figure. So let's be honest and precise. This was not a random moral panic, no. This was content that collided with religion, sexuality, dignity, and public morality in a deeply religious society. So after the video was uploaded, people made complaints, and the Kenya Film and Classification Board responded. Now, here is the important part. KFCB did two different things, and the entire case turned on separating them. First, they reviewed the content and said it was inappropriate for public exhibition. Second, they issued a demand letter. Not just a warning, a demand. They told Getumbe, you have violated the Film and Stage Plays Act by recording a film without a filming license. And then you distributed it without approval. Therefore, you now owe us 243,200 shillings in licensing fees. So, this is where the law enters the group chat. KFCB's legal argument was straightforward. The Films and Stage Plays Act calls a film as any recorded audiovisual medium. A YouTube video is an audiovisual. A music video is an audiovisual. Therefore, it's a film. And if it's a film, higher. Section 4 says you need a filming license before production. Section 12 of the same act says the finished film must be examined before exhibition. Then 16 says it must be approved. In other words, should have paid the government before pressing record. Yeah. So Getumbe goes to court. His argument was not, my content is holy. No, it was, this law does not work in the real world. The Film, Stage and Plays Act was enacted in 1962. And it was written for film studios. Cinemas, projectors, and reels. See the Instagram. Not smartphones, not YouTube, not TikTok, not instant uploads by millions of ordinary Kenyans. Because if KFCB's interpretation was correct, then every Kenyan with a phone was already in breach of the law. Yeah. Every skit, every vlog, every church live stream, every politician's apology video recorded in a car, all of them illegal, all of them unlicensed, and all of them chargeable. That's not regulation. That's a constitutional accident waiting to happen. The case landed before Justice L N Mugambi. And the judge here does something crucial. He does not start with outrage. He starts with statutory interpretation. He reads the act carefully. Then he agrees with KFCB on one uncomfortable truth. The definition of film in the act is very broad. And it's broad enough to include audiovisual recordings made on smartphones. So Getumbe is wrong on one thing. The act is not limited to film studios. But this is where judicial intelligence kicks in. Akili mtu yangu. The judge asks a deeper question. Okay, even if the definition is broad, can the licensing scheme actually be enforced as KFCB claims? And the answer to that question is no. The Constitution says this clearly and devastatingly in a country where anyone with a smartphone can record a video and upload it instantly. Requiring every person to obtain a filming license before recording content for public viewing is ludicrous. Get back. You don't know KFCB like that. Not difficult, not inefficient, ludicrous. Impossible to enforce, arbitrary in practice, and selective by necessity. So a law that only works when the state chooses who to apply it to is not a law. It's discretion dressed up as a regulation. So the court draws a hard line. KFCB misread the act when it applied sections 4, 12, and 16 to demand licensing fees for amateur videos uploaded to social media. That 243,200 invoice, null, void, and enforceable. Because your phone is not a film studio, but, and this is the part social media ignored, the court does not fully side with Getumbe, no. Because the judgment does something grown up. It separates licensing from content control. So the judge says that that licensing framework is outdated and unworkable. But the purpose of the act, that's protecting children and vulnerable members of society from harmful content, that is still valid. We still have to do that. The thing is, technology has changed. The harm has not disappeared. And therefore, KFCB still has authority to act after publication, to restrict or require removal of content. That's still in their power. So if content is deemed harmful and inappropriate, they can do that. But you cannot license phones. You cannot demand filming fees for every YouTube upload. But you can still say this content should not remain publicly available without classification, restriction, or some cases, removal. And that distinction matters because the court also addresses the constitutional rights claims. And the claims were, 1, freedom of expression. And they said that's not absolute. Limiting content to protect children is reasonable, okay? Under Article 24, that is, and crucially, Kinyanjui was given notice. He was given 7 days, he was not ambushed, he was not silenced overnight, and he was never actually challenged. He never actually challenged the law. And finding out the content was offensive, aliendelea tu na maisha. So this was not a censorship gone mad case. It was a case about using wrong legal tools and a real regulatory problem. And then the judge delivers the quiet but devastating conclusion. This is not something courts can fix alone. This is a law reform problem. Okay? You cannot regulate modern digital life with colonial era legislation and still expect fairness after that. And still expect consistency after that. Still expect legitimacy after that. So the constitution may be modern, but technology is fast. And the law is tired. And unless parliament updates it, tuko na shida. Every Kenyan with a smartphone remains one invoice away from accidental criminality. So what does that petition by William Getumbe Kinyanjui actually teach us? People, you're free to create, but not free from consequence. The state can protect society, but not by pretending your phone is a cinema. And morality, no matter how deeply you feel it, must still travel through the constitution before it reaches your screen. So if you own a phone, with a camera that is, this judgment affects you. If you post online, this judgment protects you. And if you thought the government could charge you before you pressed record, the hacker looked at that idea, looked again, and said very calmly, no. So if you enjoyed this breakdown, share it, subscribe, and join us next time on Katiba na Chai, where the law meets real life and reality keeps moving faster than a statute book. Till next time, this is Katiba na Chai.